Hello and welcome everyone. Good afternoon to this information event on the Financial Market Infrastructure Act. Today we will inform you about the implications that this proposal on the Financial Market Infrastructure Act has on issuers, investors and in general the market participants. We have here Lutz Meyer from SIX, the Public Affairs team, who will inform about, in general, the Financial Market Infrastructure Act, what it is and why it is it was enacted. Then we have Corinne Reguzzi, who will describe the role of SIX exchange regulation. Andrea Rüttimann, who will say what the changes are in the new proposal. And we will also have Felix Künk from Swiss Holdings, who will explain you the position of Swiss Holdings on that. So now I hand over to Lutz. Welcome to the stage.
Thank you very much, Vera, and good afternoon also from my side. Let's do it. The next 10 to 15 minutes, I would like to set the scene, what we are talking about, what kind of law is affected, what other kind of laws are in that space, and why we are discussing the whole thing. Someone of you might recall the Shamrock reform or the Kleeblatt reform. It was a topic 10 years ago where 4 pieces of law have been introduced or defined and designed. And one piece, actually topic of today, is the Financial Market Infrastructure Act. Just shortly to describe the other 3, Financial Market Supervision Act. This is the law where it's defined that FINMA is kind of the main body to supervise things. There's also a consultation, just actually has been announced last week, if I might, or the week before. The Federal Financial Services Act, which is more tackling point of sales topics, so all banks to the end clients in a nutshell, and the Financial Institutions Act, which covers all the different players in the market. In the white column you can see also a bit the wording and the short names of European law, because as you know, in Switzerland we have outcome-based regulation, which is not as extensive as we have it in European law. So we are using 10 pages where Europe needs 100 pages. First of all, in the Financial Market Infrastructure Act, comparable laws are MiFID and MiFIR, Market and Financial Instrument Directive and Regulation, EMIR, European Market Infrastructure Regulation, CSDR is regulating central securities depositories, and MAD stands for Market Abuse Directive, and actually we have now a regulation as well. So all these different European laws are condensed, filtered into the Financial Market Infrastructure Act. And sometimes I'm using FMIA and sometimes FINFAC. Please apologize. FINFAC is just easier to say and stands obviously for Finanzmarktinfrastrukturgesetz. Entry into force was 2016. And why are we discussing this now? There was a review clause. They have already designed, when it has been introduced, after 5 years, we will do a comprehensive review of the thing. And actually this has happened. And on the next slide, I come to the timeline to outline a bit where we stand. But I think it's quite important also for today's session that we know what is described and ruled in FINFAC. Because it's not only about topics like market abuse, insider list, and so on. All the different licenses are regulated in FINFAC. Licenses, when I say licenses, stock exchange license, for example, or a CSD, Central Securities Depository license, or payment license. Everything is ruled in that law, in that piece of law. So that's a kind of main element of it. Then you might remember after financial crisis, there was a topic, derivatives markets are quite intransparent. We need to shed light on these markets. So all the things around derivatives, trading, clearing, reporting is also in the FINFAC. And the main piece, topic of today is all the things around market abuse, holdings, insider list, etc. And we have some deep dive sessions in the following presentations. As I said, after 5 years review clause, and when they announced, actually they published the message, they said FinFAQ has largely stood the test of time. So in general, and you can see it on the next slides, yes, it works. Of course, there's room for improvement always, but in general, it's good. And especially also having in mind a bit other laws, international laws, European law or UK law. You know, equivalence is a huge topic for us as SIX. And you see the political dimension of equivalence tests with the EU. But with UK, we have equivalence now on the stock exchange side. So the FinFAQ is in a good shape. I think that's the message. So where do we stand? As I said, the evaluation report, so what needs to be changed, has been published in 2022. Then last year has been spent of drafting the dispatch, everything. And this year, mid of this year, on the 19th of June, the Federal Council has published a consultation. And the consultation will last until the 11th of October. So roughly 2 weeks' time to go. And what we expect is in the next year, the publication of the dispatch and the amended act, and obviously start of the parliamentary process. This has also been announced, I think, in the targets of the Federal Council for this year, I think 2 weeks ago. And then 2026, it's an ongoing parliamentary process. And then obviously it's not only the act which needs to be drafted and consulted on, but we have also ordinance level, so the second level of legislation which needs to be defined. And then if everything works well or not well, let's see. In 2027, we expect an entry into force, which might then also shift into 2028, depending on the developments. So it's a longer time process, but this is quite crucial at the moment because this is a public consultation and everybody should respond and look at the documents. So this is actually just a copy and paste, and this is what it's actually about, and I don't want to repeat myself. Financial Market Infrastructure Acts, quite technical, not relevant for today. Main changes are proposed around systemic important infrastructures. We, for example, have 2 of them, if not 3, depending how you see it. It's about capital requirements, and it's about payments. What is a payment system? What is not a payment system? What kind of thresholds where you have to apply for license and so on. This is all the thing around financial market infrastructures. On derivatives trading, also a few proposals are on the table. It's also about what is in and what is out when it comes to reporting of derivatives transactions. For example, for non-financial counterparties, quite technical. When you are in, when you are out, when you have to report and when not. Derivatives trading here is, I think, worth mentioning that we as SIX, we have also a SIX Trade Repository, which is the receiver of all the different reports in Switzerland. And topic of today, and I really can keep it here short because we have deep dives later on. It's all, I covered it under the phrase market abuse, all about insider list, ad hoc publicity, shareholder obligation, and so on. Very important is, let's see if it works, this sentence here. It works. Well, let's see. Today, oh no, it doesn't work. Let's see. The basic principles of everything is defined under self-regulation. In simple terms, under Corin's shop, in the regulation of SIX exchange regulation, which always needs to be approved by FINMA. A lot of things will be shifted then to the act, to the law, and Corin and also Andrea will then deep dive on that. I think it doesn't work. You're changing the slides. Perfect. And with that, I would like to hand over then to Corin. Thank you very much.
So hello everyone, a warm welcome also from my side. I'm happy to give you an overview of the status quo of the regulatory bodies of the exchange. So as of per today and also as of per the last 15 years, what we're doing since then and what our duties and responsibilities are. We start with the legal basis. Lutz mentioned the Financial Market Infrastructure Act, and it is about the organization of financial market infrastructures, of course, and also of the rules of conduct. And I think it is very important that the aim of this law is to ensure proper functioning, also transparency of the markets, stability of the financial market system, protection of financial market participants, and equal treatment of investors. So this is the base of everything what we're doing, and it's always to be into consideration for everything what follows. The self-regulation itself, it's laid down in Article 27 of this Financial Market Infrastructure Act, and it says that all the exchanges, so every exchange in Switzerland has to have an own regulatory and supervisory organization. That has to be appropriate to their activities. So a smaller exchange has smaller bodies, and the bigger exchange like SIX has bigger bodies. Everything that is also very important is subject to the supervision of FINMA. So it is not just done what the exchange wants, but everything is supervised. This means not only the body itself and their work is supervised, but also the people working for these bodies are supervised. We are all approved by FINMA. We need to have to provide proper business conduct, good reputation, specialist qualifications, and we have to be independent. I think these are very important points that we need to have. And it is also important that all the regulations and amendments have also be approved by FINMA. So this is not, you could think that self-regulation is just the exchange doing the regulation by itself, but it is not, it's very strictly regulated and organized. We have some more details in the ordinance, in Article 24, regarding to the legal provisions that we have to fulfill, and is said that we need one body has to be responsible for the regulatory tasks, another one for the supervisory tasks, another one for admission of securities to trading, and an appeals board. These are the ones that have to be at least in each exchange in this supervisory organization, in this self-regulation. It is also further written down that all the bodies have to be independent and they have to be adequately equipped in a way of an organization, personal and also financial resources. So how is this implemented within SIX? Within SIX, on the right side, you can see the SIX group. So with the board of directors, a little bit simplified, the executive board, and also the business unit which runs the exchanges, SIX Swiss Exchange, which most of you know, the SIX Digital Exchange, and the repo. And then beside that, we have a whole organizational structure with these regulatory bodies, which are independent from the group. And there is no reporting line. I report to the chairman of the board, but not within the tasks. It's just about the budget. As I said, also here, everything is supervised and approved by FINMA. So we have first the regulatory board, that is the one that issues all the rules, kind of the legislative. The people in this board are making the rules for the exchange. And then next we have the commission, the sanction commission, the judicative bodies, with an appeals board and also a court of arbitration, so you can appeal the decisions of the sanction commissions further on. So kind of the court within this system is responsible for all the sanctions. And then we have SIX Exchange Regulation, this is us, the executive part, and we are responsible to monitor all the regulations that have been issued by the regulatory board. And if we see something that is maybe not right, then we have to investigate it and bring it to the Sanction Commission for decision about is it right or wrong. So it is kind of a small democracy within the whole system with all the 3 independent bodies. So it's quite a balanced system. So this is what I just said. A short summary, we have the regulatory bodies, one for issuing the rules, this is the regulatory board, monitoring compliance, the SIX exchange regulation, us, and enforcing is done by the Sanction Commission. Now, who is in this regulatory board? Who is making the rules for the exchange? And it's very interesting because these are external people. They're not working for SIX. These are market participants. They're very close to the market. We have representatives from investors, from issuers, listed companies, of course, also from banks. So it's quite broad. We have 17 members. They're elected for 3 years. Also FINMA approved, each of them. And they work in committees also, so they meet each other 3 times a year to issue the new regulations, and in these committees also another 4 times a year. So they meet each other quite often because the rules have to be changed quite often, and it is quite a lively environment, of course, as you can imagine, regarding the exchange. So I listed you the member. I'll leave you a second. Maybe you know some of them, probably yes. I guess, as I said, it is important. It's all experts. They're all very close to the market. They're all working in this environment. They know the market quite well. They know all the exchanges and what is going on. They know it from different perspectives. And we also have investors that are represented in this body. So these are the ones that are making the rules. And once they've decided, so sometimes a lot of discussion is going on in this board when they discuss the new rules, and then we have to take it back and change it again. But when it's final, we have to let it approved by FINMA in the end. Sometimes also FINMA gives inputs and they want to have to change something. Can also happen. But after all, then it's in place and then it's the new rule. Regarding this second organ, the Sanction Commission and the judiciary bodies, as I said, they're responsible for the decisions, for the sanctions, to impose the sanctions. They're also independent, completely independent. They have different possibilities to sanction, going from a reprimand to fines, also suspension of trading. They can delist something, exclude somebody or a company from further trading. And their decisions can be appealed to the appeals board and further, if necessary, to the Court of Arbitration. Who are these persons? Probably you know them as well. Also broad, also expert, close to the market, coming from banks, professors. We have the chairman is president of the Commercial Court of the Canton St. Gallen, so they know a lot about trading, they know a lot about topics regarding financial reporting. They're really in their company in these topics. And I think this is very important because it's a very specific topic, all this regulation of an exchange. It is not what a court usually does. Which can be quite broad, but this is very narrow and very specific, so it's quite worthwhile to have these people in here. All the sanctions that the Sanction Commission decides about are published on our website. It is important to be transparent, so all the other market participants can see what has been decided already. Maybe it gives them a guidance what has been decided as being correct or maybe not correct. And it also builds a practice over the time. So as I said, SIX exchange regulation exists, or this setup, the whole setup exists for 15 years now, and we've built up quite a lot of practice in this year, also a lot of changes, but you can read everything on our page if you're interested. It's very lawyers-based. So what is SIX exchange regulation doing? So our part, the executive part, the third element of these bodies, we are monitoring and ensuring compliance. and we are divided and working into 2 areas. We have on the one hand all the things that have to do with issuer regulations, so the listed companies that are regulated, and then we have the trading surveillance, which is mainly responsible, of course, for the trading, the surveillance of the trading, and they are in interaction with the participants, the banks, and the traders trading the shares. And on the issuer regulation side, we have first the prospectus office, where the prospectus is approved from us. And then we have the listing, a company coming to the doing an IPO and coming to the exchange. And after that, we have all the obligations that the listed company has, such as corporate disclosure, which means ad hoc publicity and also management transactions that have to be reported. We have the corporate reporting, so means the financial reporting, also corporate governance, all the duties that a company has to make transparency to the public, to the investors. So everything that a possible investor might want to know or wants to know about this company. And the investor wants to know quite quickly about who is having the also disclosure office, that the shareholdings, who is owning this company, what is going on in this company, what are the financial reporting of the balance sheet of this company. So just always very investor related, always transparency to the investor. On the other hand, we have the trading surveillance. They, with a very sophisticated AI tool, they're detecting market manipulations and insider trading and also violations against the trading rules. And they detect quite a lot, actually, and it's very interesting. If somebody's interested, I can maybe continue after the session, because today we concentrate a bit on issuer regulation. But it's quite interesting, and we also developed this this trading surveillance tool. We are always developing it further, and it detects quite a lot. Once we see something, we do a report regarding insider trading and regarding market manipulation, and we send it to FINMA and also to the Bundesanwaltschaft, Federal Prosecutor's Office, for further investigation. This is what we're doing on this side. Altogether, we're between 50 and 55 people. Most of them lawyers, auditors, economists, and also former traders. So this is a summary of what the Department of the Listing and Enforcement, the Issuer Regulation, is doing. So as I said, the IPOs, all the issuer obligations are monitored as ad hoc publicity, management transaction, disclosure of shareholdings, and financial reporting. And if we see something, we do an investigation, and then we send a proposal about a possible decision of a sanction to the Sanction Commission. It's also important to know that the Sanction Commission decides completely independent. They're not bound to our proposals. So sometimes they change the sanction completely to what we thought. On the other hand, we had this trade surveillance department that is responsible to monitor the trading on the exchange, to find possible insider trading, to find price market manipulation, sending the results to FINMA and to the Bundesanwaltschaft. So why is this self-regulation system useful, successful, and very practical in this whole exchange environment? The regulatory board especially, and these judiciary bodies, they're very close to the market. They're really experts, and they bring in all the know-how from their practice. So it is very, very close, and the market participants are making the rules for the market participants, so it's broadly accepted. It is also very efficient and very quick. For example, last year, we had a spec regulation, which came up very quickly, and within a few months, we had a completely new regulation from the scratch. And we did not have to go through parliament, or not every party had to be involved, but it was just very on the topic, and everybody was involved who needed to know. And then we had a very quick regulation after a very short time. The same is applicable for the judiciary bodies, the Sanction Commission. Once we've done the investigation and all the proceedings, and we submit the proposal, they're very quick to decide. They know a lot about the topic, and it's very useful, I guess, also for the for the issuers to have a quick decision, and also for the market to have a quick decision. So in this very rapidly changing international stock market environment, it is a very important factor for the success of an exchange. And last but not least, it's just because not many people know it, this self-regulation model is worldwide very dominant. Also Canada, Singapore, so Japan, Brazil, very important financial marketplaces have a very similar system. The exception is the EU, so they don't know it. And as we are in the EU, we mostly think we are the special ones, but we are not compared to the whole world. The EU is the exception. I think it's important to know if you're talking about self-regulation. So just a few words about the revision, but Andrea will come to that in detail. So these are as per status quo, the obligations after the listing of a listed companies, the financial reporting, corporate governance, reporting obligations, stock publicity management transactions, disclosure of shareholdings. This at the moment for the issuer and for the companies is everything within SARE, so they report everything to us, and we make sure, the issuer itself as well, that everything goes quite quickly to the investors and to the public. And the new setup would be, just that you see it first, the ad hoc publicity and the management transactions would be uplifted to the federal law. There is also an obligation to maintain insider lists. I guess for the issuers, these are the main changes that might be critical or maybe unwished. It is not yet clear what it really means. It's just clear it goes to the federal law. But who then in the end is responsible for issuing the rules or amending the rules or doing all the work that has to be done in the context of ad hoc publicity and management transactions, and also who is doing the enforcement is not yet defined, definitely. It will be in the ordinance, and so we don't know really yet. It has certain uncertainties in it. But this would be the new system, it would be cutted out, some parts. And Andrea will tell you more about this. Thank you.
So a warm welcome from my side as well. My name is Andrea Rüttimann and I'm a lawyer in the capital markets team of Niederer Kraft Frey. As mentioned, in the next 20 minutes, I would like to show you what impact the revision will have on you, your companies, and you will see also on your relatives. I will start with a recap of the status quo. So basically what you are facing as a listed company now. Then quickly repeat the revision for issuers in particular, followed by a deep dive of some of the rules. And then at the end explain what a sanction proceeding could look like under the new regime. So let's start with, we go into the details of this overview. You've seen the slide just before. As a listed company, you have various disclosure obligations. Generally, you have obligations at the listing, so be it the initial listing or also a capital increase thereafter. That's fulfilled with the listing prospectus you see on the left. And then thereafter, you have disclosure obligations basically after the listing. In German, they are the so-called Aufrechterhaltungspflichten. These can be divided into some you have to fulfill within the annual report or the half-year report. That's the financial reporting and the corporate governance report. Then some just to maintain the orderly trading, that's the so-called standard reporting duties. And then you also have event-based disclosure obligations. So obligations you only have to fulfill if a certain event takes place. That's the ad hoc publicity and the disclosure of management transactions. Both of them are in connection with prevention of insider trading. Then, additionally, and that's more of an duty for the investors, there's the disclosure of shareholdings, where the issuer has the duty to publish the report. And then also on the slides, because it's also connected to the listing, are the takeover rules. So any disclosures you have in case of a public tender offer. And then I think you're familiar with that from the Swiss Code of Obligations. You have duties in connection with compensation, the compensation report, and then the non-financial reporting obligations, which is basically the sustainability report. To summarize from the legal grounds, from the legal basis, you see on this slide with red or pink, basically, frame, you see those duties which are founded in federal law, and with the blue frame, those duties which are currently founded in self-regulation. And as mentioned, self-regulation of the stock exchanges, that means that the stock exchange establishes, monitors, and then also enforces the respective rules. To show you, and that's maybe quick repetition from what we've heard before, what happens in case of a potential violation of one of these self-regulated duties. The process usually starts with a preliminary investigation conducted by SIX exchange regulation. There the issuer has the possibility to participate. So basically to establish the factual background, there's a written back and forward. If based thereon, on the factual background, SEER comes to the conclusion that there is a violation, it submits a sanction request to the Sanction Commission. And there the issuer has the possibility, which is commonly taken, to also hand in a counter statement. So it's important, so the sanction request and the counter statement of the issuer are submitted to the Sanction Commission together. What we see in practice is that Sanction Commission makes a decision, and this decision is in most cases accepted by the issuers. But however, the possibility is there, the decision of the Sanction Commission can be appealed with the SIX Appeals Board, and this decision can be appealed for limited grounds only with the SIX Court of Arbitration. It was mentioned in the previous presentation, these judiciary bodies, they're all composed of representatives of issuers, representatives of investors, academics, and also independent practitioners. In the practice, however, we see very often that investigations are stopped on the first level, so with a simply warning letter without any further procedure. And this serves the purpose very often sufficiently enough. Good. Let's move now to the new rules. It was mentioned before. So those issuer obligations that are connected with insider law, those are transferred from the self-regulation of the stock exchanges to federal law, with the consequence that FINMA will be involved in the future, and also a criminal sanction can happen. So if you recall that overview from before, you see now that that red frame now goes also for ad hoc publicity and management transaction. And also obvious from this slide, you see that the self-regulatory part is smaller and somewhat also fragmented. let's go now into the specific rules. We start with the publication of insider information. So that's the new term. That's the ad hoc publicity, how it's called now. There, the Erläuterungsbericht, or the Federal Council in the Erläuterungsbericht, which was published together with the draft will in June, states very clearly that the current case law and practice of SIX will be largely adopted. So that means that content-wise, and please take this with caution because we will need confirmation of this and also clarification in the implementing provisions, which we have not yet seen. But content-wise, on the topic of ad hoc publicity, there should not be too much of a difference to the regulation how it is now, content-wise. You see here on the slide, I mentioned that the term will not be price-sensitive fact anymore, but insider information. In academia, there's a certain discussion whether these terms are the same, but I think in practice this will not be very relevant for you. Then insider lists. This is a new obligation. So from a currently best practice, this will be a legal obligation to maintain insider lists. For those of you who are familiar with the requirements of FINMA for the financial institutions, it will be similar to that watch list requirements that are in the FINMA guideline. And the obligation will also be relevant for issuer of bonds. Additionally, those lists have to be kept for 15 years. And I made a small research whether we have a comparable long duration, for example, in accounting or financial reporting, and it seems that the 15 years are quite a unique long period. Important that non-compliance with this duty is subject to criminal law. So that means if someone in your organization deletes the insider list after 14.5 years, this is basically punishable, technically. Whether the Federal Finance Department will assess this as, will pick it up at first, and when it picks it up, assess it as being punishable is a different question. I cannot assess this right now, but technically this would be subject to criminal law. Then management transactions. I think here we have the biggest changes for you. For once, the reporting duty is extended to issuer of bonds and issuer of derivatives. So far, the duty was only for issuers of shares. Among the only bonds issuers, you have large companies like Raiffeisen, ZKB, Axpo, but you also have very small enterprises, for example, in the infrastructure sector, where you have a hospital or a power plant issuing just one listed bond to raise capital. So for their members of the management committee and of the board of directors, they will in future have to support management transaction reports as well. Also new is that the name and the function will be published, so the name and the function of the manager. So far the name is always reported to SIX, but SIX does not publish the name on the public platform. And in future, everybody will see the names on the public platform. Has to be said, it's in the EU, there's already this regulation. Then another novelty is also the subjects that are, they have to fulfill this reporting duty. At first, it's of course the company, so the issuer who has to publish the reports. and also instruct the managers and operate a proper system where the managers can hand in their reports. And then secondly, it's also the managers themselves, so the members of the executive committee and board of directors who are now personally directly subject to that reporting duty, as well as their related parties. So related parties can be persons of the same household or, of course, legal entities under the control of those managers. That's new because the stock exchanges so far could only reach out to the issuers, so to the company, and also only sanction the company. There was no direct relationship between the stock exchange and the manager. But in the future, there will be the managers and their related parties. So basically, everybody could be affected by this rule. Then a next new obligation is blackout period. I have to say a vast majority of the issuers have blackout periods in their internal guidelines around the publication of financial information. The law will in future state statutory blackout periods, which are then fixed in the FINMIA. Nothing too extraordinary, I have to say, but important to note that transaction during these blackout periods by managers will be subject to criminal law, regardless of whether they are actual insider trading, just by the mere fact that a transaction takes place in this statutory blackout period. And then at last, from these rules, the large shareholder disclosure, I will keep it a little bit brief here because, as mentioned, that's more of an obligation on the side of the investors. But for you as issuers, important, the 3% threshold will be cancelled. So the entry threshold will be at 5%. That means if your shareholders will not register in the share register, you are up to 5%, you're kept longer in the dark about your shareholder base, and also if any shareholder activist can enter directly at 5%. Good. Let's move now to the sanction proceeding, or what we know about it, how it could look like under this new regime. So what happens in case of a potential violation of one of these said rules. It was mentioned before in the previous presentation about the organizational structure. We don't know that much yet. So we don't know yet whether the monitoring of the duties will take place on the level of the stock exchanges or on the level of FINMA, or how the responsibilities are going to be shifted between these two bodies. But what we know, in case potential violation is picked up, that FINMA procedure can kick in, and that means that each issuer and also each person subject to reporting duty on the management direction, management transactions has now a direct supervisory relationship with FINMA. That means FINMA can also apply its instruments directly to these people. That can be that you have to provide information or that you have to submit documents. Could also be that FINMA opens a formal enforcement proceeding, and then as a quite a severe measure of FINMA, we have to say that it confiscates the profits out of such a violation. In parallel to the FINMA procedure, there will also be a criminal procedure. So FINMA forwards the reports to the Federal Department of Finance. Likewise, the Federal Department of Finance can take direct actions against the issuers and the person obliged to report. And here I can say what we see in practice, because in the area of large shareholder disclosure, we already have this set up. The large shareholder disclosure is regulated under FINMA already. So we see that already, the FINMA procedure, and usually it's thereafter the criminal procedure. And we see there very lengthy proceedings, so it can take that the Federal Finance Department only takes a sanction 6 or 7 years after the violation has taken place. And also, even if the amount of the fines are maybe not extremely high, but we see formalistic processes also for very small, trivial cases. So after this rather tense information, I would also like to leave you off with some good news also. And here we go for my last slide. So while criminal fines have been introduced, the frame for the fines has been significantly reduced. That means from now a maximum of 10 million in intentional cases to a maximum of 500,000, and from a maximum from 1 million for negligent violations, which is in practice way more relevant, to only 100,000. To be complete and also to be fair, the actual amount of the fine is usually not the biggest part of the cost. You have, depending on the case, you might have reputational damages. You have always internal resources which are bound by these proceedings, and you also may have costs with legal representation, which is the lawyers basically. So with this, I thank you for your attention, and I'm happy to take questions in the Q&A session. Thank you.
So, good afternoon also from my side. Thank you for the invitation. I'm delighted to present our perspective. And our perspective, that's Swiss Holdings and its member companies on the planned revision of the Financial Market Act. Who are we? Swiss Holdings is the Federation of Industrial and Service Groups in Switzerland. Our 65 members represent approximately 60% of the total Swiss market capitalization on Swiss exchange. So in numbers, that's roughly 1,800 billion Swiss francs as of March 24. You have learned from my colleagues and previous speakers the proposed amendments to the Financial Market Infrastructure Act and the consequences thereof to the processes and procedures with 6 exchange regulations, the supervisory board, and the judiciary bodies. My aim today is to highlight the importance of self-regulation in the Swiss financial market and explain why we should maintain this proven practice. Although the revision proposes certain adaptations to technological development and international standards, I'm convinced that we shouldn't sacrifice the flexibility and efficiency of our existing system. Self-regulation has proven its worth over decades. Companies and institutions have consistently maintained the necessary stability and innovative strength through practical regulations. Let's now look at the objectives of the revision, the alleged shortcomings, and their impact on self-regulation. Let's examine the objectives of the revision more closely. Firstly, strengthening the financial stability and competitiveness of the Swiss financial center. A noble goal, certainly, but I ask you, isn't our financial center already stable and competitive? Self-regulation has significantly contributed to our strong international standing today. Secondly, adaptation to technological progress and international standards. Yes, we must keep up with the times, and we support the changes proposed with regard to financial market infrastructure, in particular the capital requirements and the provision on resolution plans, and with regard to derivatives trading. Thirdly, simplification of provision and cost reduction for market participants. A laudable task, no questions, but I fear the reality could be quite different. The transfer to state regulation could, or will even, as we heard from Corinne Riguzzi earlier on, lead to more bureaucracy and higher costs, not less. Finally, improved investor protection is sought through stricter regulation on market manipulation and insider trading. Here too, we must critically question, do we really have a significant problem with market manipulation or insider dealing in Switzerland that justifies this tightening? Let's pause for a moment and consider the actual purpose of FINMIA. Pursuant to Article 1, Paragraph 2, FINMIA's purpose is to ensure the proper functioning and transparency of the securities and derivative markets, the stability of the financial system, the protection of financial market participants, and equal treatment of investors. Firstly, ensuring the proper functioning and transparency of financial market infrastructure. I ask you, hasn't self-regulation already successfully guaranteed this? Secondly, ensuring the stability of the financial system. Here too, self-regulation has proven its worth. Our financial institutions were weathered recent crises well. Thirdly, protection of financial market participants. Self-regulation has always kept the interests of all parties in mind. And fourthly, ensuring equal treatments of investors. This too has always been guaranteed by self-regulations. What are the alleged shortcomings? From the explanatory report on the opening of the consultation procedure, I'd like to quote the following statement, with the first part standing out. The Federal Department of Finance concluded that FINMIA has proven itself overall, but that just adjustments are necessary in certain areas due to technological developments, further developments in international standards, and the legal framework of relevant foreign jurisdictions, particularly in the EU. Regarding the improvement of the stability of the financial system, yes, clarifying the concept of a systemic importance, introducing gone concern capital for systematically important financial market infrastructure, and anchoring the comprehensive preventive resolution plan at the legislative level are important points. We welcome these and recommend their implementation. Turning to market integrity, the explanatory report argues that given the importance of issuer obligations for preventing and detecting insider trading and market manipulation, it's not appropriate to leave these obligations to the self-regulation of stock exchanges. Instead, state regulation should ensure that all relevant interests are comprehensively included in these designs of these obligations. The key point of the revision is the transfer of important issuer obligations to the self-regulations, to state law. This particularly affects, as we heard in detail from Andrea, ad hoc publicity and management transactions, and the requirement on keeping insider list, which in future would be monitored by FINMA. But is this really necessary? I ask you, ladies and gentlemen, couldn't these points have been implemented within the framework of self-regulation? Let's wait and see what self-regulation is capable of before we act hastily. Regarding the optimization of the reporting system, the Federal Department of Finance calls for a uniform reporting format to improve the quality of reports in the area of trade monitoring. And again, the questions, is dissolving the self-regulatory system really the only way to achieve this goal? I dare to doubt this, especially in light of the principle of proportionality. We should rather examine whether the introduction of a uniform reporting format couldn't also be implemented within the existing self-regulatory system. SIX exchange regulation respectively the regulatory report has repeatedly proven in the past its capability of efficiently implementing complex technical requirements. Moreover, we must ask ourselves, are the alleged quality deficiencies in reporting really due to the self-regulatory system? Or are other factors at play here that we overlook so far? In my opinion, a thorough analysis of this question would be appropriate before we act and abandon a proven system. Is self-regulated the system of doom, as the explanatory report wants us to believe, based on rather overall allegations than on evidence? Self-regulation is more than just a concept. It's the heart of the Swiss financial market system. It allows market participants, especially exchanges like SIX, to react flexibly to changes while maintaining high standards. In concrete terms, this means SIX develop its own set of rules, which must then be approved by FINMA, as we heard. The system of approved self-regulation allows for timely responses to market changes without having to wait for lengthy legislative processes. This is a decisive factor for the competitiveness of the Swiss financial center and simultaneously ensures the integrity of our markets. Let me highlight the advantages of self-regulation even more clearly. Firstly, industry-specific expertise flows directly into regulation. Who could better judge which rules are practical than those who operate in the market daily? Secondly, also, acceptance of the rules among market participants is higher. When the actors themselves are involved in shaping the rules, these rules are better understood and implemented. Ladies and gentlemen, giving up these advantages would be more than just a mistake. It would be negligent towards our financial center. Let me present the concrete arguments for maintaining the self-regulations. Sorry, wrong button. The approved regime. Ladies and gentlemen, it is a misconception that market participants regulate themselves completely freely, as we learned. This is not the case. FINMA approves all proposed regulations and changes. It's noteworthy to say so far all changes or regulatory initiatives by SIX regulations have been approved by FINMA. In rare cases, the self-regulatory authority withdraws a proposal if the time to market is no longer given. This demonstrates, I think, the efficiency and appropriateness of the system. Proportionality. The principle of proportionality is a cornerstone of Swiss law. It requires that any administrative measure for achieving a goal in the public interest must be suitable and necessary. Moreover, the purpose must be in reasonable proportion to the burdens imposed on private individual. I ask you, do the proposed changes to the self-regulatory system really correspond to the least possible intervention? Can it be justified to overturn the entire self-regulatory system just because the reports allegedly don't have the desired quality? I'm convinced you agree with me, this cannot be justified. Flexibility. Self-regulation allows market participants to react quickly and effectively to new developments. In the past, SIX regulation has repeatedly proven that it can respond more agilely to market changes than a state regulatory system ever could. As we've heard from my previous speakers, the self-regulation body consists of experts with special knowledge and experience. Enabling market-driven regulation, specialists ensure the procedure are implemented quickly and practically without lengthy state intervention. And as we heard already, one of those examples are the SPACs, so the special purpose acquisition companies, where the regulatory proposal was set within under a year, or also the global depository receipt, the GDRs, where regulation was proposed here within a very short time frame. Efficiency, through the direct involvement of market participants in rulemaking, practical solutions emerge. This efficiency would be significantly impaired by the state regulations, which often react rigidly and slowly to changes. Let's consider the duration of a legislative process. It first involves the preliminary work by the authority the task is delegated to. And we heard from Lutz, I think, what was it, in 2022, where they started the preliminary work. Then you have the discussion in the commission of the first council itself, then discussion in the second commission, in the commission of the second council, and finally the second council. And even more, you could have interactions if they don't agree on the same terms. So you can imagine that this process is much longer than what we right now experience with the self-regulatory regime. Costs. The introduction of a central reporting platform and the expansion of FINMA's supervisory capacities would cause enormous cost. These costs would ultimately be borne by the market participants and taxpayers without any apparent added value. But no costs estimate is available for the introduction of the new system to be operated by FINMA. But it's clear the taxpayers will have to pay for the expansion of the state apparatus, and listed company will face high additional costs. This will arise because of change from the existing system to newly built system. Additionally, issuers will have to increase their compliance departments to meet the newer requirements, especially on the expansion of criminal liability. A system change that causes such high costs should only be implemented if there are significant deficiencies in the current system, which is not the case here. Supervision. On the one hand, FINMA already supervises the self-regulatory authority, as we learned. Audits are conducted several times a year, and the instrument of on-site reviews is also available. On the other hand, the proposed revision, the circle of addressee, the circle of addressees will be expanded with the so far FINMA supervised the banking and the insurance sector, and now it will also supervise the entire issuer market. So you have a direct connection to FINMA. And I ask you, is such a fundamental expansion of supervision based on the alleged deficiencies necessary? International competitiveness. Many leading, and as we heard, financial centers such as the US, Singapore, Japan, and Canada successfully implemented and rely on self-regulation, which is accepted by the International Organization of Securities Commissions, the IOSCO. This allows them to react quickly and practically to global market changes. There, the direct involvement of market participants is seen as a significant advantage because it enables solutions to be implemented quickly and practically. So why should Switzerland, a country known for its innovative strengths and efficiency, abandon this proven system? The flexibility that self-regulation offers us allows us to react to global market changes faster than state regulations ever could. This is a decisive competitive advantage that we should not give up lightly. We must not underestimate the role of self-regulation in maintaining and enhancing the attractiveness of Switzerland as a financial center. Our system of self-regulation has been a key factor in attracting international businesses and investors to our market. It offers a unique blend of flexibility and stability that is highly valued globally. The proposed changes risk undermining this attractiveness. By moving towards a more rigid state-controlled regulatory framework, we may inadvertently send a message that Switzerland is becoming less business-friendly. This could lead to a decline in new listings, reduced foreign investments, and potentially even encourage some companies to consider delisting or relocating. Moreover, our current system allows for rapid adaptation to market needs and innovation. This agility is crucial in today's fast-paced financial world. It enables us to quickly introduce new regulations, as we learned, where necessary, keeping us at the forefront of the global finance. A more cumbersome state-regulated system could slow down this process, making us less competitive on the international stage. We must ask ourselves, are we willing to risk this hard-earned reputation of Swiss financial market as an innovative, efficient, and attractive place to do business? The unique selling proposition of our financial center is at stake here, and we should think very carefully before making changes that could diminish our global appeal. In conclusion, I want to emphasize self-regulation is a decisive competitive advantage for the Swiss financial center. It's flexible, efficient, and cost-effective. The proposed changes to the law, especially the transfer of self-regulation's task to state regulation, carry the risk of over-regulation. This could significantly weaken the competitiveness of the Swiss financial center. My appeal to political decision makers is therefore critically examine the necessity of these changes. These are not compelling reasons to abandon the proven system of self-regulations. Instead, we should work on optimizing and further developing the existing system. Let's ensure together that the Swiss financial center continues to be competitive and best in class through flexibility, efficiency, and innovation in the future. Self-regulation is the key to this. Thank you for your attention.
Thank you very much. Only 2 slides to go. First of all, thank you to Corinne Reguzzi for describing the current setup of SIX exchange regulation. I think it's quite important to understand the current setup, especially it's independent of SIX. Of course, the brand is SIX exchange regulation, but it's independent of SIX, and it's always under the supervision and approval of FINMA. That's quite important. Thank you to Andrea for describing the changes, the current setup, and also the proposed changes of the revision of the FINFRAG, and also to Felix for sharing the view of Swiss Holdings, how you see it. Especially, I found interesting the aspect of attractiveness, because it's all about competition, and especially if you look at Europe, Draghi report for people who are watching the financial legislation at the moment, it's all about competitiveness. And UK, after Brexit, the same. And I think it's not good that we go a step back and making our things even more complicated than it's necessary. On the next slide, it's about our position, and we have heard a lot of things around self-regulation, and our position, which we put in our consultation response by the 11th of October, is as follows. First of all, we share the opinion that the FINFRAG is good, doesn't need a change. If it ain't broke, don't fix it. Better focus on competitiveness instead of just changing the rules just for the sake of changing the rules. The system works well, and in our opinion, a far-reaching redesign is therefore not necessary. Yes, as 6, we also welcome some proposals. 6, not the self-regulatory aspects, but in general, when it creates certainty around payment systems, clarification about financial market infrastructures, etc., we support that. Some aspects need changes. Yes, there are some mistakes in it, which needs to be fixed. But however, as we have just heard, we also reject the proposed changes, the structural changes around self-regulation. And that's why overall, we come to the conclusion that we have significant reservations in that consultation. As you know, and as Felix outlined, there's a process now happening, not only in the dispatch, but after also in the parliamentary process. Yes, we can change things at this point in time, but as we know, it's a quite specific topic. You can imagine that not everybody is keen to look into that topic. So I think it's now a good opportunity to raise your voice, to say, to share your opinion, because it's quite important at this stage. I would like to guide you to a microsite. We disclosed the microsite, and I think the slides will be shared after the event, I would guess, so everybody can click on the slide. First of all, the consultation, once again, 11th of October is the deadline. And join us in our response, in our views, share your response. Very important, on the microsite you find, again, the arguments, so you can use these arguments if you share them. Quite important, and we are really counting for your support. And I think with that, we are done for the event, and now we're starting a Q&A, so please join me on stage. Do we have a microphone, or is it going around? Yeah. Any questions on the side?
Thank you. One question to Andrea. You mentioned the reduced fines. Can I assume that the reduced fines will apply after or to violation after the entry into force of the new regulation?
You mean whether there is a hope that they already apply it now?
Exactly, yeah. Well, I mean, not now, but I mean, because I mean, typically those cases take quite some time to get to a fine, and they could be 2 or 3 years during which a violation could occur, and once the case is, let's say, judged or appealed, then the new law is in force.
Yeah, thank you for the question. That's a good question, especially because these procedures are so lengthy, as I said. So we very often see that the Federal Finance Department just comes to the end, to the sanction very shortly before the statute of limitations, so the fediero kicks in. So they really take it to the end. I think it's a procedural question, and you have on the criminal law, you have the principle of lex meteor, if I remind correctly. It's definitely an argument you would have to bring up, that if the draft bill comes into force like that the will of the legislator was to significantly reduce the fines. But as if I can add that, as I mentioned, so the actual amount of the fine usually doesn't bother the issuers so much. It's really the extra costs on top of it, and also, even depending on the case, the reputational damages they may face.
Maybe if I may add something, until so far, SIX exchange regulation or the sanction commission, I think the highest ever fine that they issued was 2 million. It was 10 years ago. So since then, we're lower as well. So it is not, we don't use the whole framework of 10 million. It never happened.
This is a question for everyone on the panel. Do you think that the FINMA has the necessary resources to conduct this additional supervisory power? And if not, are you of the view that this should also be included in your response during the consultation process? Or is it a bit difficult for SIX to bring such an argument forward because you're being directly supervised by SIX?
Of course, we as SIX, to give an answer is difficult, but I think you can imagine that's not cheaper at the end, I think. But it's not only about cheaper or not cheaper in cost, it's also about speed, time to market. I think this element is even more important than the other one. Yeah, but it's, as I said, it's from a SIX perspective always difficult to say, you know, it's more expensive, it's more expensive. We are interested also in the attractiveness of the financial center. It's not only about who does what and how expensive it is. But if it's getting more expensive, it's less attractive. So, yeah.
But I think if I may just add there too, that's something what I tried to touch upon in my words. I said, you know, with regard to the cost, it's clear that FINMA has to increase their employees. It's no question. So therefore, you know that there will be costs attached there too. Someone has to bear them. It's either by taxpayers or it is, how would you say it, Gebühren?
Fees, at the end, fees.
Fees you have to pay at the end for, if I think if I'm not mistaken, there has been a quote in the consultation paper that there will be fees clearly for whatever kind of report you have to report in. So there, and what's the price tag to it, that's unknown so far. But I think the one thing is you need first the manpower to do it. Second, you need the experience of the manpower to do it. To be at the same level where you have a regulatory, self-regulatory board which consists of the professionals will be quite, in my opinion, a hard task to achieve. And there is always a price tag to it if it's, how should I say, if you're not so experienced into it, it will be more lengthy, it will take more time, it will be, and more time always is cost.
I think there was a question over there. Was it been answered?
Can you hear me?
It's on here.
Thank you. Maybe just a statement rather than a question. I think it's important to also acknowledge that taking on something from the clearly from the EU is something that in practice probably doesn't work that well. We at Nestle, we have bonds listed on EU regulated markets, and our team basically covers the SIX ad hoc or the SIX compliance, but also the EU compliance. And we see that, for instance, like the insider lists, it's just it's a ridiculous exercise. I mean, it just doesn't add any benefit. And comparing that with how we do it in Switzerland, it's just a lot more practical, and the result is actually even better. And the other benefit of the self-regulatory regime And Felix Küng, I mean, you already mentioned all the important points, but it's in the EU, and I don't name which EU member state, but we have the difficulty that when we have an issue, we need to discuss that issue with the regulator. Sometimes it's even ESMA, and it's super difficult to get through to them, to get clarity, and sometimes we just need to do something, so we need to react, but then there's no reaction basically, so no response. So it leaves kind of a limbo and uncertainty, and that's much better handled by the self-regulatory regime. So I just wanted to kind of like emphasize that this is something that may be missing. We've looked at the statement that Swiss Holdings prepared, but the statement should be why taking something on that works in theory, but then in practice just doesn't work at all. Just wanted to say that. Thank you.
Yes, I have a question for Andrea, and it's linked to the statement of this colleague. In regards to this mandatory requirement to keep this insider list for 15 years and the practicability, so what is your view on this? How should issuer of bonds and shares deal with these requirements to implement it? So is it in an IT system, and does someone from IT needs to observe it for 15 years, or is it with legal or compliance? So what is your view on that?
Yeah, good question. Look, I think the first thing you can do now as an issuer of shares or bonds, because it applies also to issuers of bonds, to hand in something in the consultation period now that these 15 years are really, let's say, ridiculously long, right? And thereafter, that's a very practical question, and we always see it if there's, for example, when there is a change in personnel that supervises that the specific task, and I see it in practice everywhere, basically with every duty. Mistakes happen very quickly there. So it's really has to come from a practical side, a solution, how you are organized as an issuer. But the point is so taken that the 15 years is just ridiculously long.
So I was wondering, I think we have a really good understanding now of what's being proposed, but since this is also a political process, what is the argument to change the regulatory approach? I mean, is the perspective of the authorities that something's not working, or that the risks are higher? I mean, because what we've heard is that everything's fine, and I think we're happy with the approach that we've had so far. So where's the impetus for this change coming from? That would be very interesting to understand.
Yeah, maybe I can add a few words on that. First of all, I think it became clear it's a lack of the impact analysis, to be honest, because to say, as I think on one slide we said, technology developments, international developments, but that's it. There was no concrete impact assessment and been done, to my knowledge. So to use the argument, the world is changing, we need to adapt, it's not enough, it's not reasonable. Send it back to the sender, yeah, it's one option. As I said, in our position, it's the balance. Please stick to the rules. You don't have to change it, it's working. And if you believe it's not working, be transparent, what is not working, and then we can adapt. But the fundamental change It's not necessary. Why are you doing that? Please focus on competitiveness. That's the message. But first of all, it's a lack of the impact assessment or the transparency around that assessment.
But I think it's a very interesting point because we had the same issue. We tried to find in the explanatory note or report what is truly a deficiency. And it's more like, you know, overall there is, okay, we have to adopt to EU regulations or we have to adopt to certain other things. But there was no clear messaging within the report to say self-regulation didn't meet the needs as required. And I think that's why we, especially as Swiss Holding, trying so hard to push there that there is definitely no need and no reason to change from the self-regulation to state regulation. But it's a fair point. We were happy to have someone in here to find in the documents this crucial part, but it's not.
I would be interested in learning from Swiss Holdings what your position is on the 3% versus 5% shareholdings obligation. I learned that it's going to be lifted from 3 to 5%. What's your position on that?
There we also support this uplift to 5%. So we didn't receive from our member companies any different, how should I say, reactions that we should stay to the 3%. And I think that was also one of the selling points to be more cost efficient. How should I say, from the authority, because they said, you know, if you have to do the 3% and then the 5% as well, that's cost intense. So if we get rid of one of those thresholds, there will be less burden. But it's a small one compared to the others. But as said, we didn't have any negative, let's say it like this, feedback on that the rise from 3 to 5 is an issue.
Yeah, maybe I can add here. So the Swiss large disclosure system is really a difficult one. It's very complicated compared also to other jurisdictions, where actually other jurisdictions also start at the 5%. So that's in line with that. And what we see, and I think what also the authorities saw, that many of those negligent small little violations happens on this 3% voting rights threshold. And that's also a facilitation in that way, that there should be less criminal sanctions on that very small cases there. So that was a little bit the background, I understand. So that's a pro, right? Mm-hmm.
A question regarding practice of for ad hoc publication rules. You mentioned that the initial draft says something along the lines of that SIX practice would be adapted, and it's a little bit fluffy, of course, and what that means. But are there examples from other areas of regulation where FINMA has taken on practice from a different authority or so and then quickly changed its approach? I mean, is there, or like, do you have experience around other areas of regulation where FINMA either continues a practice for a long while, or do they tend to look at it after 1 or 2 years and decide, oh, we'll want to do it completely differently?
Comment. Hast du ein Beispiel?
No.
Yeah, I mean, maybe it comes back a little bit to that organizational structure. You know, if FINMA really takes over those tasks, and as we heard, SIX exchange regulation is now at an organization of 50 people, 55 people, so FINMA really would take over those tasks. I think, as we mentioned, that would be quite an exercise for them. So I think, but please just take this with caution, and that's also a little bit a personal assessment of the situation. But I think at first they would definitely just stick to the rules that are around, which are, as we heard, which are working, which are practical, because that's just not that the knowledge is not there, the workforce is not there to establish a different practice so fast. And thereafter, could be both ways, honestly. Yeah.
But I think predictions are hard to be made, but it's just out of my previous experience where I worked before, there are, or how should I say, what is FINMA, or what is the power of FINMA? They have the power to issue circulars. And circulars sometimes tend to take certain aspects out of, how should I say, the law. Or you can change your circular whenever you deem it appropriate. I had the experience that during an application they just changed it and we had to redo the entire applications again, which to me is a little bit the strange part if you're in, how should I say, you're playing the game and then you just, by the way, okay, let's start it again. And I think that's something what you has been kept in mind, because I think it's also what you have to see with the adaptations. Six exchanges can do in this rapid, with the knowledge they have. That's something which FINMA at the end is not able to do, because the one thing is in the law. So if you want to change the law, you have to take the entire process through the law. So the legislative process has to be adhered to. And the same thing is with the ordinances. You can change them a little bit faster, but still it goes through the legislative process. So that's quite the, how should I say, for me, clearly an advantage on what the regulation has at hand so far. And therefore, if you have, how should I say, the overall rules are in the law and the ordinances, it's hard to change. Or it might be that through circulars there could be adaptations, but I think it's hard to predict, and it's time will show on what's going to happen.
Can you elaborate a bit more on the practical consequences of being under the direct supervision of FINMA? Notably, should we now expect external auditors, to look into our ad hoc or management transaction disclosure process?
Yeah, as I said, I mean, when we look at the material which we have now, it's basically only the draft bill and the Erläuterungsbericht. So that's, and that first review report from 2 years ago. So that's basically all material we are currently looking at. So the organizational setup is really unclear yet. But what you have and what's already in the draft bill, that FINMA is involved, and with those measures, if you recall my slide, so it's the duty to inform and hand-in documentation, the enforcement proceedings, and the confiscation of profits. Those measures are explicitly mentioned, whereas, for example, the professional ban, for those who are familiar with FINMA measures, so the Berufsverbot is not mentioned. So this is something FINMA, or is already in the law, that FINMA is not allowed to take that measure. But from the rest, I think the possibility is, and what we see, that's really not, when you ask about experience with FINMA, that's more from the regulatory banking side. FINMA has certain open doors, so there is the possibility to speak, but we also see a lot of personnel changes, for example. So first you speak to person A, and then 2 months later, suddenly it's person B responsible for the case. So it's unclear from the material we have now. It really will need to be seen how the implementing provisions will spell out what exactly it means.
Any further questions, remarks? Well, maybe there and then here. Just a second.
Yeah, I mean, just wanted to follow up to the question regarding insider lists. Because, I mean, now all issuers, at least issuers of shares, when they start price-sensitive projects or, certainly in case of postponement of price-relative facts, the disclosure of postponement of price-relevant facts, already have, right, this kind of insider list. So to what extent the insider lists that might be newly requested or required, how different are those? I did see on your slide that the timing of as to when the person has been privy of a new fact needs to be added, but how different is this new list versus the list that we already have now?
Yeah, again, I'm very sorry to not be super precise on this, because we really just have the material we have now that we have to try to answer this question. But I think it was taken up previously by someone. So the EU has very specific requirements how insider lists must be maintained. And what came from the Erläuterungsbericht, that it's not these EU requirements. So at least on the level of the Erläuterungsbericht, it's now clear that it doesn't have to be that onerous format of the EU. For me as well, I think the vast majority of issuers keep insider lists in a proper way, and I think from the organization, my best guess would be that it remains basically the same. But the thing is, if you don't do it, or if you don't keep it that extremely long, you're just with one foot in a criminal sanction, which is a huge difference than to now that you're not. Of course you should, but it's a best practice, right? I think the difference is really there.
How optimistic is Swiss Holding that they can influence the political decision-making process so that they come back to a reasonable approach?
We try our best. It's, what should I say, 50-50? I'm convinced more at the end, because as I said, I just don't see the reason why. For me, that's the big part. And then it's more the question on how convincing we can propose. But I think that's one of the key aspects Lutz just took up. The more issuers, participants, companies respond to this draft consultation or to this consultation and raise their concerns that self-regulation should not be, how should I say, should not shift from self-regulation to state regulation. If that's not the right key, please raise your voices. And I think that's the most important part, because I think just that you have a little bit the political perspective. Sometimes they just look at how many pros did we get and how many yes, no's or yes. And then it doesn't depend on what exactly you said. So, if it's, how should I say, if we are Swiss Holdings, we are for sure responding to this consultation, but it's just one. So if it's at the end 1 to 10, they would rather say, okay, even it's just one. They don't look at the size, what we're representing. It could be. It's always like this. So that's why I'm saying it's difficult to predict, but I think as said, and as we heard the questions as well, what is truly the reason why they want to abandon the self-regulatory regime? There, I haven't seen it. It's just more like, and therefore that's what, how should I say, gives me the hope that we have there the power to, with good arguments, to convince from the other side.
Okay. So we all know what we have to do as a homework, huh?
We welcome it.
Thank you.
Any other questions? Marks, just checking the watch. So I think if there are no further questions, it's for me to invite to the apéro. First of all, thank you very much for joining the event, and as we said, counting for your support. And I think we prepared a little apéro outside, so if you have any questions, feel free to ask during a beer or a glass of wine or water. Thank you very much.